Causation appel del fil wing del an it del it is it break. Score del is des appel wings del forward it del it hinge of del it riven is why it del green I roll 30 of flying complain I want 10 charts. The quarter keys of frame dash 1 article 5 of dark del key 5 of wall del night for ein six wow. Indir del uf six wow. Del road del contributor be del word spirit of work donis I win art for of del whose bench April del subindil sub of what Kringwin del Desperate or the Ultimate Cruise of del I Crow del I del Tac Warp Chunrown Working del Posis el Provis Head or Quan Place in for regionals.
Judgment of fair instant deny labor court as the circus as called to is the first instant proceeding corresponding by judgment house May 9, 2020, declaring orange the defendant to pay the plaintiff. The amount has 770,792,617 as compensation for hazard dismas. Judgment has second instant. The labor chamber has the superior court of the judicial district has called. Upon resolved the appeal, had the defendant by judgment has June 11, 29 confirmed the judgment has the first instance. Publicar publicidad multimedia sustained the termination has the contract without has cause. To conclude, regarding the value has the independent it counted that the liquidation judged have value has 707,404,304 bu held that the mammoth estabas hindi judgment had fair instant will be persevered.
He added that in response to the right of petition presented by the company denied the legal indemnity, and that the territorial direction of the Ministry of Labor informed that there was two recourse for the closing on the company by Publicar Publicidad Multimedia. Therefore, the company did not comply with the requirement of authorization from the Ministry of Labor to close to the work. Arguments. Dismissal without just cause. The last position held for the defense was Labor Code. The company notified the decision to terminate the contract for legal cause during the administrative termination that resulted in the disappearance of the job mark and the word, since it was necessary to eliminate in the disappearance of the job made of war. He added that in response to the right of petition presented by the company denied the legal indemnity, and that the territorial direction of the Ministry of Labor informed that there was two recourse for the closing on the company by Publicar Publicidad Multimedia. Therefore, the company did not comply with the requirement of authorization from the Ministry of Labor to close to the work.
Replica. It indicates that when accusing the direct violation the determination of the labor standard that the adjudicator should have applied was not complete with. The appeal present seek the appellate and interpretative effect on the civil contract to the employment contract. Text being substantially different. Remember that the application of civil norms is carried out only in the event of gap in the labor law and provide that the civil concept that is intended to be appealed does violate North's concept of principles of labor law. It concludes that since there is no erroneous application of the legal norm by the adjudicator, the charge cannot prosper. Consideration on the judges. The concludes that although the profitability of the firm's circumstance cannot be attributed to the worker, the court addresses Article 47 of the Substantive Labor Code support by two decisions of this Court of Cassation that indicate that the disappearance of the case and the matter of the contract don't represent that it can be understood to have been terminated in a legal and justified manner.
Taxation. To publicar publicidad multimedia SAH. Non exonerate in from assuming the compensation of damages for non-purchase in decision on a legal cause or on just cause. Before the compensation legal stipulation in Article 64, the Substantive Labor Code was appropriate and any viewed that, in addition, the affected worker would have to assume a legal action aimed at proving and assigning the damages. Taxation. To publicar publicidad multimedia SAH. Non exonerate in from assuming the compensation of damages for non-purchase in decision on a legal cause or on just cause. Before the compensation legal stipulation in Article 64, the Substantive Labor Code was appropriate and any viewed that, in addition, the affected worker would have to assume a legal action aimed at proving and assigning the damages.